Hi, I'm Theron, specialist divorce and matrimonial attorney from Johannesburg. Hope you enjoyed my blog last week on divorce and what to do, what are the basic steps if somebody, you're a partner, wants to initiate divorce. As promised today, I'm just going to do a short bit on fathers and custody. I'm going to be reading a bit from an article I recently wrote, and so excuse me if I'm reading, but this has been published and it's, I think, good and basic advice. So, whether you're a father, married or unmarried, it's obviously easier for a married father to prove his parental rights and responsibilities because he automatically has them if you're not divorced yet. For an unmarried father, you have to prove your Section 21 rights. What does that mean? You've got to prove that you've earned your parental rights and responsibilities towards your child. I don't agree with this. The Constitution says you can't discriminate based on gender. Yet you can be a heroin addict mother. If you gave birth to a child, you have automatic parental rights and responsibilities. If you're an unmarried father, you still have to, and you're an accountant that pays your taxes, you still have to go and prove your Section 21 rights, which I believe is blatantly unfair. So in terms of Section 21 of the Children's Act, Section 21, Children's Act 38 of 2005, what must you do to prove that you have parental rights and responsibilities towards your child? If at the time of the child's birth, you were living with the mother in a permanent relationship, if you weren't living with a mother, but you consented to be identified as the child's father on the birth certificate, or in terms of customary law have paid damages, and that is a big bone of contention there. I have a lot of fights about that. Or contributes or has attempted to contribute to the child's upbringing. What does that mean? Nobody quite knows exactly what that means. Or contribute or has attempted to contribute to the child's maintenance. That's fairly easy enough. Okay, right. So, coming back to married fathers, Section 20 of the Children's Act says if you were married to the child's mother, or if you were married to her at the child's conception, birth, or the time in between birth and conception, then you've got parental rights and responsibilities. So what happens in a situation like this? Now I'm going to deal with whether you get divorced or whether you are not married. The same document applies. It's called a parenting plan. A parenting plan needs to be drawn up by a specialist matrimonial attorney. It deals with the following issues. If you look at Section 33 of the Children's Act, with whom will the child be living? Who will be the primary parent? What contact it will have with a non-primary parent? Maintenance payable by who to who? Contact between the child, the non-custodial parent, and extended family, schooling and religious upbringing, and alternate dispute resolution mechanisms. Meaning that in terms of the Children's Act, if you and the mother fight about or disagree about care and contact arrangement, which another term for custody, then you have to mediate before you litigate. Right. Can a father, the big question I always get asked, can a father get custody over a mother? A father can most certainly get custody over a mother, but you have to prove one thing in terms of Section 7, the child's best interest. So if the mother has emotional problems, if the mother is transient in her work, goes from boyfriend to boyfriend, continuously moves around, where you stay in one area and you can provide the child with stability, a loving and a caring home and a nurturing home, where the child can grow and develop and knows what the next day brings, well then you're in with a shot. It is much more difficult for a father to get custody than it is for a mother. In our law, it is said that the tender years doctrine and the maternal preference doctrine does not exist. That's a blatant lie. It does exist. I had it quoted back to me the other day in court by a very senior judge. Oh, but the child is of tender years. How can we have it go live with the father? The father's had a wonderful relationship with the child, a strong relationship with the child, and the tender years was used as a bar to having us have shared custody as in 1 week rotating. What do we have to prove to the court? Section 7, the child's best interest. Who should you brief? You should brief a specialist matrimonial attorney to draw up the parenting plan, and that parenting plan must then either get signed by both parties and then registered with a family advocate and then made an order of court. Alternatively, if the other party does not want to cooperate, then you apply to the Children's Court to have that parenting plan or terms in line with that parenting plan made an order of court. So it's either via consent or via litigation. Consent is always the easiest route. Consent, mediation, and only then litigation. So if you have any more questions, contact me on www.divlaw.co.za. That's www.divlaw.co.za. as in div, as in the three first letters of divorce law.co.za. We're in Johannesburg. We consult anywhere in the country, and as a matter of fact, anywhere basically in the world as well with these kind of matters. So contact us. More than willing to assist you. Next week's blog is going to be about contested relocations. Contested relocation meaning you're divorced or you're not divorced, and suddenly the mother has met somebody in Australia over the internet, and now she wants to take you and your children and relocate to New Zealand or Australia without thinking of what that's going to do to your relationship with your children. See you next week.